Hi, I'm Greg Dell here with attorney Cesar Gavidia. We're going to talk about the standard and reviews of the standard. And Cesar, on our website, we have a lot of reviews from people that have policies with standard, have had positive or negative experiences. It tends to be more negative experiences. But these reviews are great because people get to learn about the experiences of other people that have standard disability policies. They also get to learn about things that will help them to either avoid a denial or keep them on claim, and we really encourage people to post these reviews. We try to share all of our experiences with standard through cases that we've handled, cases that have been filed in lawsuits. But the perspective I want to give people here is, from this video, is to hear from your experience having reviewed hundreds of denials from the standard and spoken to thousands of people that have the standard and reviewing all of those policies. What is it that leads them to have this experience of having a negative, review of the standard? But specifically, starting out, when someone calls you and they go, Cesar, I got this claim with standard, they just denied me. What comes to your mind when you think about the standard versus the 20 other companies that you usually work with?
So, as you mentioned, I've handled thousands of cases involving Standard Insurance Company. They're based out of Oregon, in Portland, Oregon, and one of the things that I recall just from our, the many years we've been dealing with cases with them, is that they have a very unique way of managing and reviewing disability claims. You usually are not dealing with people that are inexperienced there. Sometimes, in cases where there may be a larger benefit, or it's a specific type of occupational, professional, or profession-based disability policy, you might actually have a lawyer as the claim representative. I remember we did depositions where we discovered that the person who was the claim representative had a Juris Doctorate degree. So you're dealing with some pretty sophisticated people typically when they're reviewing claims. And I've seen some of these denial letters come in. Sometimes. Okay. But one thing in particular with standard, and we get a call, and one of the first things we ask for obviously is the disability policy, but also the denial letter. We want to review the denial letter that because they have to explain and give the basis for why they're denying the claim, if they relied on any doctors, reports, whatever information they have, they usually have to provide it in that denial letter. Standard's denial letters are usually extensive. I mean, I'm be surprised if I encounter a denial letter that's 2 or 3 pages long with Standard Insurance Company. Usually their denial letters are 9, 10 pages or more. So they go through a complete medical history, then they go through the reports that any doctors or medical personnel have provided that are giving them the basis to denying the claim. Sometimes they've conducted quite a bit of surveillance on a claimant. It all depends, but it's usually all in there, and it's quite extensive, and that's pretty unique with them.
Yeah, it's interesting when you started talking about standard because it reminded me about their internal reviews, how a lot of companies will go to their own doctors or their own nurses, but standard has some pretty decent protocols as to going to specific medical specialties more often than not to review the claim, as opposed to just going to a general nurse to review a claim, which, when someone has an orthopedic doctor or a cardiologist and they're going to a nurse, really that's not the most appropriate medical specialist to try to rebut the opinions, or concede or acknowledge the opinions of a specialist doctor. So unlike many other companies, they seem to be of the opinion to say, yeah, we should reach out to the appropriate medical specialist for reviewing a claim. But standard as a whole, what is it specifically in their policy language? Because these policies are written, you get what you pay for, right, per se, and the standard people are asked to follow the policy language and determine if the person's restrictions and limitations match the language of the policy. Mm-hmm. What types of language or provisions in their policy do you think cause frustration for people that lead to denials?
Well, one of the things that comes to mind is with the definition of disability itself. I mean, this is kind of the main provision. If you're going to read anything in your disability policy, you read the definition of disability, because that is telling you there how you become eligible for those benefits, right? So these definitions the definition with standard often reads that if for the first 24 months of your claim, you're disabled when you're unable to perform the substantial material duties of your own occupation. Okay, and one of the things with the standard policy is people think, oh, well, how I perform my specific job for my specific employer, or this, there are very specific and unique things about how I do my job for this particular company. They don't care about that. They're looking at how your occupation is performed on a grander scale, on a national economy scale. That's the standard that you have to meet with standard. That's pretty frustrating because people's jobs and occupations can vary, even though they have the same title, even though they may have generally the same type of thing that occupation that they're performing. It's going to vary from company to company. There's going to be different requirements, and there's going to be different expectations from employer to employer. So that's one of the things that is particularly frustrating with some people when they contact us and they don't understand how they're comparing them to how this job or their occupation is performed on this national economy standard or as defined by the dictionary or Department of Occupational titles. So then there's a transition. They go from 2 years of own occupation to now having to meet a whole new standard of disability, which is your inability to perform any gainful occupation that you're qualified to perform based on your education, training, experience. And that's a pretty standard eligibility requirement in group disability policies kind of across the board. But and what they look at there, they're looking at particularly, again, your work history, your education, what kind of training and certifications you've received. And they're doing it more on a grander scale. They're not looking specifically for how you do things, but how you can potentially transition your skills into some other work, even though you may have never done that before.
You talked earlier about these longer denial letters, and earlier today I filmed some other videos with some other lawyers talking about these typical, the quantity and quality of a denial letter that comes, and most of the disability companies do a 3 or 4 page denial letter, and they're usually 3 pages of boilerplate, summarizing the policy language, here's the history of your claim, here's your ERISA rights, and then there's maybe 3 paragraphs or 2 saying, our doctors did the medical review and here's why you're not disabled. That's pretty much the norm. Standard does a more extensive denial letter, but with that being said, would you say that standard leans more towards trying to find a reason that a person is eligible for benefits, or trying to look for more reasons to say why they're not eligible for benefits?
Because they're looking at more reasons to find that person may not be eligible for benefits. They think they're covering all the grounds. They try to get it all knocked out in that first time with that initial denial. Then usually they're telling you towards the end of that letter is that you have 180 days to appeal their decision if you disagree with it, right? Expect their appeal denial letter to be almost twice as long as that initial denial letter. Because whatever they didn't cover that first time, and they're going to build on that, now they're going to try to cover in their appeal. So if you're not attacking, all of those reasons and addressing all of those reasons that they're denying you, and really doing a comprehensive and extensive appeal of that denial of benefits, you can expect that they're going to cover everything and more in that appeal decision.
So what most people don't realize who aren't in the industry, the reason that standard's doing that is because most of their policies are governed by the arbitrary and capricious standard, which means that if you lose your appeal and it goes to court, that if there is a discretionary clause, and some states don't have that, and you can search our website and talk about what is a discretionary clause, that basically means that the judge has to determine whether or not the disability company acted reasonably. It doesn't matter if he thinks that the claimant's disabled or not, just did they act reasonably. And I think that, to Standard's credit, if I was looking on their side, they've done a decent job of at least painting the facade of doing a decent job, because they're putting a long denial letter in, so they go, Judge, we did 9 or 10 pages of information. Now, most of it's probably a summary of just the medical records there, which they sent out to have reviewed, and then again, they still only have probably 2 or 3 paragraphs adopting whatever their medical review experts did. But what Standard's trying to do is play the game. They're trying to say, look, we reviewed everything, we went to our experts, they rendered an opinion, and Judge, we're entitled to choose the side that we want. We don't have to give more weight to their doctors than to our own doctors. And that's what we did here. So I agree with what you're saying, that it's making it more difficult for claimants. It's not necessarily that they're looking for reasons to try to approve the claim, because you probably see just as many standard denials from them as we do from the bulk of all the other disability companies.
Right.
Is there anything in your experience in terms of when you're reviewing a standard policy that's like a specific limitation that these claimants should be aware of?
Yeah, one thing, well, you know, aside from what you find in most group policies are these mental nervous limitations, where if you are disabled due to a mental nervous condition, usually a psychiatric disorder or something, depression, anxiety, bipolar disorder, sometimes all these things fall right under that. You know, you're limited to 24 months of benefit payments. There's also, and this is also something unique to many group policies with standard, is a neuromusculoskeletal or subjective symptoms limitation, which means if there is not a objective way of establishing that you have this condition and that you have limitations from this condition, then they could limit your claim to, you know, 2 years, 3 years, whatever it says in the policy as far as the limitation is concerned.
And do you find that in most of the group policies?
You do. You see that a lot. And where I see it come in and really kind of, well, you say, well, you know, if they could do an MRI, well, then that's not always enough. Sometimes you have to find evidence of radiculopathy. Maybe you have to go beyond just an MRI and now do EMG nerve conduction studies and show that there is, you know, nerve involvement or nerve damage as a result of you know, your herniations or as a result of your spinal condition. So, and even when there are those things, I had a case that I'm recalling with standard where all of this showed up in my client prior to their surgery, to their cervical fusion. And they had the surgery, and it's not that these symptoms went away, but there was a correction, you know, to the spine.
They had the objective evidence pre-surgery, post-surgery, no objective evidence. But chronic pain.
But chronic pain. And they denied it on the basis of that limitation. So
there's, you know, we see it in the reviews, we see it from the hundreds of phone calls we get every year just dealing with standard people, that standard policyholders, that this is the way in which standard reviews these claims. And you have to be diligent. At the end of the day, it's all about providing the strongest possible medical evidence that you can and doing it constantly, and not just in how you submit your claim forms or your attending physician statements, but most importantly in the medical records. And that's where we coach clients and guide them to say, here's what has to be in your medical records. And medical records are electronic, and you can't just have everything that every time the doctor goes in and still has it checked, like no complaints of shoulder pain when you are having the shoulder pain. Like, it's got to be there, every single thing that's going on. If something's normal but is not normal and your doctor didn't uncheck normal, then it's going to count against you. So you have to watch every single thing in your medical records. Always be aware. If you get the evidence to standard and it's strong, I believe that they'll do the right thing. But if there's any holes, I believe that they're going to deny your claim. Yeah. Is that your similar experience?
I think that's a fair statement, yeah.
Well, thank you to the people who are putting reviews out there. Continue to share them with all the people on our site, on our YouTube channel. We have over 9,000 subscribers, so people watch these videos all the time. And the point of this is to help educate you to get your benefits paid, protect your benefits, help you if you've been denied. No matter where you live in the country, feel free to call myself, Cesar, any of our lawyers. We always provide a free consultation, and we look forward to helping you.